Good afternoon. This is the Minnesota Senate Judiciary and Public Safety Committee meeting. For the record, today's date is Wednesday, February 22nd, 2017. And right now we have a 1, 2, 3, 4, 5. We do have quorum for the record. The bills we have today are two bills. One Senate File 918 and the other is Senate File 676. But before we begin, I would like to just go over some of the rules of our committee hearing. We'd like to keep things respectful today and to respect everyone's time and be as fair as possible. We've given 20 minutes, allowed 20 minutes for proponents of the bill, which would also include our authors of the bill, and 20 minutes to those that oppose the bill to give testifying. Testifiers, please be respectful of time limitations. Angela here will have a sign for everyone to keep them focused on how much time is left remaining in your testifying. And if I could make recommendations to our committee members, let's listen to all the testimony first before we get into questions. And after the testimony, we will have that opportunity to ask testifiers questions or authors of the questions, or have discussion amongst ourselves if we choose to, or before we vote on this particular bill, if we choose to do so. Any demonstrations, clapping, cheering, sign waving, any other kind of outbursts are not allowed in the Senate chamber or in a committee hearing. And we ask our visitors to please respect that. For everyone's information, neither one of these bills is reflective of Representative Zerwas's civil liability bill that was related to demonstrations. That will not be heard by our Senate committee this year. So, having said that, Senator Ingebrigtsen, perhaps I will have you start out with an explanation of Senate File 676, but you also have Senator Housley here representing 918. What is your intention?
Thank you, Mr. Chair and members. My intention is to meld the two bills together, both 676 as well as 918 in the form of an amendment, and that's how I'd like to start out if I could, Mr. Chair.
All right. So Senator Ingebrigtsen has a author's amendment. This is the first committee of jurisdiction. It is the Senator Ingebrigtsen, would you move the A6 amendment?
Yes, Mr. Chair and members, I would move the A6 amendment.
Is there any discussion on the A6? And for the audience, this is just getting the bill in its proper form so we can discuss it and focus on the bill. It does reflect the elements of Senator Housley's bill, and we will be asking her to explain it. But as an author's amendment, Senator Ingebrigtsen moves the A6 amendment. Any further discussion? Senator Schoen.
I think, there'll be plenty of discussion, but I'm more than happy to have this as we follow up as it is as a whole moving on. There's certainly pieces that look like this amendment has some concern to me with some of the language. I'll gladly let it get into the shape that the author wants it and then have the discussion after the testimony and move forward. I just want to lay that out there, Mr. Chair.
As we mentioned before, we're allowing any discussion, amendments after the testifiers are done giving their testimony. Senator Latz.
Mr. Chairman, just to amplify what you said, it's typically when there's an author's amendment, the first committee stop for the bill. We don't have any discussion on the merits. We, as a matter of protocol, we defer to the author's position and we adopt the amendment as a committee, and then we have discussion on the policy after that.
That's correct. Senator Ingebrigtsen moved the A6 amendment as an author's amendment. All those in favor say aye.
Aye.
Aye. Opposed? The amendment carries. Senator Ingebrigtsen.
Thank you, Senators. Mr. Chair, Section 1 of the bill, it's called Increasing the Penalties for Obstructing Traffic Access to a Trunk Highway or Airport Section 1, it enhances. And before I start this, Mr. Chair and members, if you indulge myself and Senator Housley, we do have some comments with regards to the bill before we take any questions. If that works, we would like to do that. But moving ahead, Section 1 basically enhances the misdemeanor obstruction of a traffic right-of-way penalty to a gross misdemeanor if a person intentionally obstructs traffic that is entering, exiting, or on a trunk highway, or that is entering or exiting an airport. Section 2 of the bill expands the misdemeanor crime to unlawful interference with a transit operator not accompanied by force or violence to include restricting passenger access to a transit vehicle, and enhances the penalty to a gross misdemeanor as well. Mr. Chair and members, some of the comments that I have, and I would like to just explain them to you if I could. First and foremost, the freedom of speech and the freedom of assembly are absolutely vital to our form of government, and we support them wholeheartedly. Second, the bill, with the A6 amendment, does not address any civil liability, and Mr. Chair, you explained that at the beginning of in the onset. Instead, it narrowly focuses on penalties in the Criminal Code, Chapters 609 of Minnesota State Statutes. It also refers to blocking traffic is already a misdemeanor under criminal and traffic laws. This language builds on what is already law in Minnesota. It has become clear that in certain situations, an enhanced penalty is needed. Freeway traffic usually travels at a high rate of speed, and for the safety of motorists and even protesters themselves, we need to make it clear that it is a serious public safety concern for everyone involved. Not only do we want to prevent a tragedy on the roadways where someone could be injured or killed, we also have to have access to law enforcement, emergency medical services, and hospitals. It's extremely important for the good of all Minnesotans. Many of these routes are the quickest pathways for ambulances to get medical emergencies and take people to hospitals all over the state. Now, if I could, Mr. Chair, let's allow Senator Housley as well as some comments.
Thank you, Mr. Chair and Senator Ingebrigtsen and members. In your packet, you will find a handout with my name on it that addresses back in December 15 a protest at the Mall of America and the airport that Governor Dayton even commented on. He called the protests irresponsible. He told NPR News that while he is sympathetic to the racial inequities that the protesters were highlighting, the disruption was the wrong way to address racial disparities. Quote, that was an extremely dangerous situation that was created there with traffic being blocked to access the airport. You had bad weather conditions, people trying to make flights, pick up people. That's way beyond what I think is an acceptable, or I should say, a responsible use of the public right to free expression and free assembly under the First Amendment. The way the A6 amendment has been crafted, it's an attempt to address exactly what Governor Dayton called an extremely dangerous situation. I'd like to address the bill on constitutionality. The Supreme Court of the United States has said many times over the years that public order and public peace are just as important to our form of government in the United States as freedom of speech. The Supreme Court has established a balancing test for these competing interests by establishing time, place, and manner restrictions. In order to pass constitutional muster, a law must be, first, content neutral, which this bill is because we are not saying anything about who can say what or anything like that. Secondly, to pass, a law must be narrowly tailored to serve a significant government interest. The government has a significant interest in keeping the streets open and available for movement, as the Supreme Court put in a 1965 case, and the government definitely has a compelling interest in public safety. And thirdly, for the law to pass, there must be ample alternatives remaining available for communication of information. Even at the MSP airport, in this same article, you can apply for a permit to protest at the airport, and there are multiple other areas available for freedom of speech and assembly than the middle of a freeway. And Mr. Chair, I'd like to have Senator Ingebrigtsen, we have some more comments.
Mr. Chair and members, with regards to the A6 amendment, that combines both of these bills, Senate File 676 and Senate File 918. We are keeping all the language in the criminal code which seems the best way to address this conduct. And again, we are building on current crimes that already exist in state law. A gross misdemeanor penalty is the enhancement of a more serious conduct at issue, obstructing traffic on freeways where it's not easy to get on or off because of the entrance or exit ramps. We are limiting the airport language to what will equal 4 airports that are considered larger in the state of Minnesota. Those would be the MSP, both terminals, St. Cloud, Duluth, as well as Rochester. These airports have control towers, have flight services, and the TSA is located on these particular airports. We did not want to go too broad to include 2 small airport landing strips, but really narrowly tailor our focus for the purpose of the enhanced penalty. The transit piece is an expansion of current law to include restricting passenger access to transit vehicles, and current language already includes a warning provision, which would be on line 2.2 of the amendment, but it is also current law. With that, Mr. Chair and members, we stand for any questions with regards to the bill.
Mr. Chairman, before you do that, if I may, could either Senator Ingebrigtsen or Housley or Council explain to us the difference between the A6 amendment and the original draft? I think it's significant. It's narrowed the application down a bit, and I think it's significant for us as we evaluate and as the testifiers testify to understand what those differences are, so that the comments are directed toward the content of the A6 amendment to the extent that they're particular to the language in the bill. I mean, for example, Senator Ingebrigtsen referred to trunk highways, but that language is no longer in the bill. So I think it'd be helpful to have that, some of those things specified.
Why don't we, thank you, Senator Latz, that's a good idea. Why don't we have Council break down the 2 versions and where we are today and what are we considering?
Mr. Chair and members, as I think Senator Ingebrigtsen said, the A6 is kind of a combination of the 2 original bills. If you start looking on the Section 1 of the amendment amends the public nuisance crime in the criminal code. That codification, it comes from Senator Housley's original bill. However, much of the language in paragraph B comes kind of more from Senator Ingebrigtsen's bill. The exception, which begins on line 1.17, this paragraph does not apply to the actions of, that's mostly from Senator Ingebrigtsen's original bill. However, it's been expanded a little to include law enforcement, other emergency responders, to clearly give them an exception. The concept of limiting, this is a new concept on line 1.15. It limits the scope of the prohibition to freeways. Senator Housley originally had controlled access highway, and Senator Ingebrigtsen had, I think, trunk highway. So now it's only freeway, which is defined beginning on line 1.21. And then it also includes public roadways within the boundaries of an airport, and that is defined on line 1.20, as I think Senator Ingebrigtsen mentioned, to only include the 4 current airports, the major airports. Also, the amendment makes it a little clearer what the mens rea would be. You would have to do these acts with the intent to interfere with, obstruct, or otherwise disrupt traffic. So that makes it a little clearer. It's not a strict liability crime in any way. Finally, the Section 2, the transit crime, that is verbatim from Senator Ingebrigtsen's original bill.
Thank you, Senator Latz. Senator Ingebrigtsen? Oh, I'm sorry, we already heard from you. We're moving on to those who are
Correct.
testifying, opposing your bill. Remember, we have 20 minutes for the opposition to speak, and they are approximately 2 minutes per testifier. So to begin with, we'll have Teresa Nelson from the ACLU give testimony. Welcome to the committee, Ms. Nelson. Would you identify yourself for the record?
Mr. Chair, members of the committee, my name is Teresa Nelson, and I'm legal director for the ACLU of Minnesota. We are a statewide nonpartisan organization with over 38,000 supporters here in Minnesota. We oppose both Senate Files 676 and Senate File 918, as well as the combined legislation, because they're aimed at quelling dissent. They're unnecessary, and they will have a chilling effect on the exercise of constitutionally protected speech, and they will prescribe punishments that are vastly disproportionate to the offense. Over the past year, we've seen a historic level of activism and protest that has spilled out into our nation's streets, parks, and sidewalks, places where our First Amendment rights are at their height. And unfortunately, what we've also seen are legislators all over the country who are reacting to this unprecedented level of activism by introducing bills like this that impose heavy-handed punishments that are designed to chill speech and silence dissent. Throughout our history, we've witnessed acts of civil disobedience, from the Boston Tea Party to the Edmund Pettus Bridge. And although in that moment those historical protests may not have garnered public support, we look back on them and we celebrate those acts of civil disobedience. These bills are not needed because we already have ample laws to address the conduct at issue. And, for example, the airport protest, I don't believe that anybody was arrested even or charged when there were bills were laws that could be implemented. And so lastly, I would just say that these bills also prescribe disproportionate punishment. Essentially, we're saying that people who block highways and cause inconvenience should be punished at the same level as people who are guilty of criminal sexual conduct in the 5th degree or malicious punishment of a child. We're also saying that they should be punished even more than people who are guilty of 5th degree assault and 5th degree domestic assault. And so I urge you to oppose this bill. Thank you.
Thank you, Ms. Nelson. Next is John Thompson from an organization, Fight for Justice Enterprises, LLC. Welcome to the committee, Mr. Johnson.
Thank you. Pleasure to meet you guys, Senator.
Would you identify yourself?
My name is John Thompson. I am a member of Fight for Justice, LLC. I'm also a member of Black Lives Matter St. Paul. I'm also an employee for St. Paul Public Schools. I'm a machinist for the district. Been with the district for almost 11 years. Most of you all know me. Philando Castile was one of my great friends, man, who was tragically murdered by the St. Anthony Police Department July 6th. I spoke to Philando on the 4th of July. On the 6th of July, Philando was murdered. Just want to share something with you. I've never protested. I've never stood out for justice. I've never had a reason to address the Senate in my life. My friend was murdered. That was enough to make me get up. That was enough to make me get up, and I will challenge you for your seat if you don't do the right thing. This is how serious I am about getting it right. This bill is clearly aimed at peaceful protesters. If you don't want people to protest, stop giving them a reason to protest. It's just that simple. And also, I know I got 1 minute. Also, the reason we are protesting is because you guys are in this chamber. Come outside. Come outside of this bubble and find out what it is the protesters are protesting about and help. Then you won't have to propose these bills. You wouldn't even have a protest. You see, the help, we put you in office to help us. All we see is you guys in this bubble, so you have no idea the police are shooting unarmed black men. You have no idea the police are tasing black men and telling them to stop resisting while their hands are behind their back. You have no idea how bad we're being treated by the police out here. Same with Somalians, same with Hmongs, same with Asians. Anybody of color except for white people are protesting. This Women's March was 99% white women. So you daggone right they had a peaceful protest. You daggone right they applied for a permit. You're actually trying to tell us how to protest now. You might as well go and tell Colin Kaepernick to just stay in the doggone, in the back of the locker room. You can't tell people how to protest and then tell them they have the right to protest. It's kind of like a two-sided sword. It's a double-edged sword. You're telling me I have the right to protest, just not like this. Doesn't make sense. We put you guys in positions to help us. When you lobby and you knock on our doors and you're asking us to please vote and support you when it's election time, we keep this, what you're sitting here debating, in mind. House File 261, no brainer. Police should have de-escalation. This right here needs more discussion, and it needs, if you're gonna draft a bill like this, just start talking to some of these African Americans who are affected by it. Let's have this conversation. So everybody sees me and thinks I'm an angry black man. No, I'm a tired black man. My friend was murdered. I've never, ever addressed the Senate. I've never addressed the governor. I've never addressed city council. I've never protested. I don't agree with you standing on 94. I don't agree with you blocking highways, but I understand where it's coming from. Do you honestly think that you penalizing people? It's already against the law. Do you honestly think that you're raising the fine? It's already a fine. That's not going to stop us. What's going to stop people from protesting is people like you coming outside, finding out what it is you can do to help the people that are mourning, that have a problem with the injustice that is being served to us on a dish. Thank you guys for having me. I appreciate it.
Thank you, Mr. Thompson. The next person is Michelle Gross from an organization, Communities United Against Police Brutality. Ms. Gross, thank you for coming. Would you identify yourself for the record?
Chair Limmer and Senators, my name is Michelle Gross, and I'm the president of the organization Communities United Against Police Brutality. Our organization has a 17-year history of working for police accountability around the state of Minnesota. I'm here to address the combined bill now. Essentially, this bill was written to increase the penalties for blocking the right-of-way and adding airports and transit systems to the areas that it would be a crime to obstruct. Other people are going to talk about the Constitution, Ms. Nelson and so forth, and the chilling effect these measures would have on protest. But as an activist, I want to talk about the practical implications of this bill. On March 7, 1965, roughly 600 civil rights marchers set out to march from Selma to Montgomery, Alabama. In what has come to be called Bloody Sunday, these marchers were set upon by brutal police wielding billy clubs and tear gas as they approached the Edmund Pettus Bridge. This is very personal to me because a number of years ago, I marched on the Edmund Pettus Bridge with Reverend Fred Shuttlesworth and other civil rights luminaries, so I feel this very strongly. Two days later, Dr. Reverend Martin Luther King, the very man who the street is named on, that our Capitol is on. He led a march up to the bridge, but the protesters were again violently turned back. Finally, protesters sought a court order allowing them to cross the bridge and march on the highway. Federal District Court Judge Frank M. Johnson Jr. weighed the right of mobility against the right to march and ruled in favor of the demonstrators. He stated, quote, "The law is clear that the right to petition one's government for the redress of grievances may be exercised in large groups, and these rights may be exercised by marching, even along public highways." As a result of these marches, the Voting Rights Act was later passed. If these bills had been law back in 1965, marchers would have been subject to harsh penalties of up to a year in prison and $3,000 fined each. If these bills had been law, Rosa Parks would have been subject to prosecution for public nuisance or even for lawful interference with transit for her courageous act. If these bills had become law even last year, recent protests at the airport in support of our immigrant neighbors and against the Muslim travel ban would have been rendered illegal. So you see, we can't really have it both ways. Protests that block highways may very well inconvenience people, but that inconvenience doesn't come close to the underlying horrors that spur these protests in the first place. Blocking highways may not be a popular tactic, but the reality is that popular tactics don't bring about change. I urge you to reject this combined bill. Thank you.
Thank you, Ms. Gross. Madeline, I may have trouble with this name, Hooley, perhaps? Help me out, sir.
Thank you, Mr. Chair. My name is Manilin Hool, and I'm the Policy and Organizing Director at Outfront, Minnesota.
I'm sorry for doing that to your name, so please
You're not.
proceed.
I'm sure you're not the first, and I'm sure you won't be the last. Bonjour, Manilin Indigene Kaz. Hello, my name is Manilin. I work for Outfront, Minnesota. Outfront, Minnesota was founded in the year 1987 in response to increased prevalence of violence against the lesbian, gay, bisexual, transgender, and queer community. Our mission as an organization is to create a state where LGBTQ people are free to be who they are, love who they love, and live without the fear of violence, harassment, or discrimination. Over the last decade, in our 30-year organization, we have engaged over 2 million Minnesotans in our work to achieve equity for all Minnesotans. The LGBTQ community has a strong history of direct action. From Stonewall to the fight for the right to marry the ones we love, we've always been in solidarity with our communities of color and other minority groups. Let us not forget that the first person to throw the stone at Stonewall was a black transgendered woman. We stand here, well, we sit here today, I guess we're sitting, because these bills are in response to, thank you for the 1 minute, to actions that people are calling out for. We're calling out for this same thing that started over 40 years ago, over 50 years ago. We're still calling for justice, and we're not addressing the underlying tones that people are asking for. This bill is trying to solve a problem that's saying that people need to stop going and doing these things, but it's not addressing the root cause. And that is what we urge you to look at. Do not pass a bill that is not going to directly change how people feel and how people need and feel called to action. That is what we do for when we look for justice in our state and in our government. And when we look for equity for everybody. Thank you.
Thank you, Mr. Hool. John Erickson. John Erickson is from the Minnesota Association of Criminal Defense Lawyers.
Thank
Mr.
you.
Erickson,
Good afternoon.
welcome to the committee. Would you identify yourself for the record?
I do. I'm here on behalf of the Minnesota Association of Criminal Defense Lawyers, and personally, I'm also here because I want to be here. I'm an attorney. I've been an attorney for over 40 years. I've been a prosecuting attorney for some 10 years, criminal public defender for about 10 years, chief public defender. I've been on the State Board of Public Defense, and I've been a private criminal defense practitioner for 20-some years. I've heard it said that the reason for this bill to increase punishment from misdemeanors to gross misdemeanors is because it will act as a deterrent, and we need further punishment. I have never, in my 40-some years of representing and or prosecuting, heard that changing a misdemeanor to a gross misdemeanor is somehow going to act as a deterrence. Anecdotally, I will tell you, it will not. There's no need for this piece of legislation to go and make punishment a misdemeanor to a gross misdemeanor. And because there is no need, because it won't work as a deterrent. It really will not. So we're speaking out against it. We don't do this very often against legislation creating crimes or the like, but we felt strong enough that we wanted to be here today and to be heard and to speak out against this piece of legislation. Thank you.
Thank you, Mr. Erickson. Next person, Brad Lato, Minnesota AFL-CIO. Mr. Lato, welcome to the committee. Would you identify yourself?
Thank you, Mr. Chair. Brad Leto, and I'm the Legislative Director and Chief of Staff for the Minnesota AFL-CIO, and here to testify today in opposition to both the Senate files and the combined bill. It seems that the goal of the legislation, of course, is an attempt to discourage the ability of people to come together and collectively express, promote, and pursue their ideas to seek positive change in civil organizing and human rights. Putting individuals in jail for a year and fining them $3,000 may well discourage some protesters. The Minnesota AFL-CIO does believe the bills are steps in the wrong direction. However, we doubt it will, as the previous testifier mentioned, stop action to seek the positive change where it is needed. You can increase penalties, but those who protest for racial and social change will continue to do so. When lobbying, letter writing, letters to the editor, picketing, and marches do not work, union, civil, and human rights and racial justice leaders have shown time and again that sometimes more visible, dramatic action may be needed to get positive change. When elected officials do not act, what choice is there? And I will just cut down on the history a little bit because it was mentioned about Martin Luther King and, of course, all of the laws that were passed at that time, which I think we would now today say they are bad and not just laws. At least I hope we would. So I believe we need to tread carefully in the area of freedom of assembly. I know that this bill could be constitutional, but the ability to drive or fly on an airplane is a privilege, not a constitutional right. We should not forget that the right to peacefully assemble or petition the government for redress of grievances is a constitutional right. Is the public inconvenience of the road at the airport is shut down to protest racial injustice or a suspect travel ban? Absolutely, that is the whole point. It is unfortunate in society that the only way people will listen to injustices visited on so many is to inconvenience people. That's been done throughout history. Dr. Martin Luther King, Mahatma Gandhi, and others sought positive change by annoying, disrupting people from their comfort levels. The bills here seek to make positive change even more difficult, ensuring the status quo. We encourage you to vote no on this bill. Thank you for the opportunity to testify.
Thank you, Mr. Lado. Next, Kay Smith, citizen. Ms. Smith, welcome to the committee. Would you identify yourself for the record?
My name is Kay Smith. I'm the widow of Jaffert Smith, who was killed by St. Paul police on May 9th, 2016. The first time I protested was when a vigil was held after Philando Castile was killed in July, and it wasn't done because protesters wanted to protest. It was done because a man had been killed by the police unfairly and unnecessarily. I was there because I had been through a horribly and similar situation, and it had gone unnoticed, and I wanted to stand up for this man and his family with everyone else. We stood up and stood together like so many had done before because we are guaranteed the right to do so by the First Amendment. This protest wasn't planned, but it happened because people were hurt and they were angry and they wanted answers and they wanted change. SF 918 and SF 676 are trying to limit our guaranteed First Amendment right and limit our voices being heard. Blocking the freeway is an inconvenience, but police killing people is far worse an inconvenience in our life too. Imagine what an inconvenience it was when the Bureau of Criminal Apprehension knocked on my mother-in-law's door and told her that my husband had been killed by the police, and the inconvenience when she called me at my job to tell me that my husband was gone. The inconvenience that I'm still going through when after almost 10 months, I'm still fighting with the city of St. Paul for the evidence to see what happened that night. If police would stop killing our loved ones, we would not have a reason to protest. Please reject SF 918 and SF 676. Thank you.
Thank you, Ms. Smith. Is Luke Anderson in the room? He did schedule, and then there was a thought that he may not show, but I'm just asking his name. Just make sure. Mr. Smith? Mr. Anderson. You are here. Okay, please come down. Mr. Anderson, welcome to the committee. Would you identify yourself for the record?
My name is Luke Anderson. Thank you all for having me today. I just wanted to echo the words of Mr. Thompson in my opposition to two bills, I guess, the amendment now. And it's already illegal. It seems like this is a completely unnecessary waste of time and waste of taxpayer money. And you're looking to bloat our already overbloated criminal justice system by stiffening fines and penalties. And I will now turn the floor back over to James and Jane Crow here.
Mr. Anderson, were you deferring the balance of your time to someone else? We have about a minute of that individual or persons. Are they here in the room? Pardon me? Oh. Clever. Meg Reed, please. Meg Reed? Ms. Reed, welcome to the committee. Would you identify yourself for the record?
Hi, my name is Meg Reed. Thanks for hearing our testimony this morning. I just want to reiterate what a lot of people have said, which is that when we block the freeway, we do so in the tradition of many others who have broken laws in order to protest unjust laws. I'd like to name Jesus, the Boston Tea Party, Gandhi, Martin Luther King, many others. I would ask the committee to consider if they would raise penalties on laws broken by those individuals and those who marched with them. I'm glad that the committee is concerned about public safety. I am also concerned about the public safety of Black people, people of color, and Indigenous people that are brutalized and killed by police in our state and in our country. If I wasn't concerned about public safety, then I wouldn't be making any of these choices. I would ask the committee to consider if there were other means of communication by which we could make our concerns heard and make change, writing letters to the editor, calling you, marching in a place where no one else is. We would probably be doing those things, and we are doing those things, but they don't seem to be working. When the legal methods of communicating to you that we need change aren't working for us, that is why we would break a law. I would just ask you to consider what must be going through people's heads when they do something like stand on a freeway for hours in the cold and block traffic and risk arrest and are arrested if their concerns were not something that you need to consider. And I also just want to make a promise, finally, that if this bill passes, if this legislation goes into effect and Black people and people of color are still being murdered by police, I'll see you on the freeway. This isn't going to deter me.
Thank you, Ms. Reed. We're now going to break from the testifying and have open discussion. But before we do, to those of you who have lost friends and relatives, I want to extend a sincere sympathy to you. And we want to do that in a proper decorum and respect. Many of us don't know what happens at a scene, but we do know the result. And it's a tragic frustration that you must live with. And this particular discussion has that in the background. We don't want to forget that. But at the same time, when protest draws more attention to the act of protest than the cause, then sometimes we get to a point where we're losing focus. And we must keep that focus on the original cause of why we're all here today. So again, sincere sympathies to everyone who's lost friends and relatives. We'll open it up for discussion. Any questions? Senator Schoen.
Thank you, Mr. Chair. And I don't know if staff has the A7 amendment available and ready to head out. And did we get the appropriate change on with the penalties? Mr. Chair, so I'm going to offer the A7 amendment, and then when it's passed out, I'll wait until everybody has it.
We'll wait till it's passed out, Senator Schoen.
Mr. Chair, I'm sorry, it's the A8 because we had to make a change. The A7 will not be offered.
All right.
It will be the A8. My apologies.
Thanks for the clarification, Senator Schoen. A8 is before us. Will there be copies for some of the public there's a lot of copies for the public, so they'll get copies. We'll wait till it gets dispersed a little further out. As it's being passed out, Senator Schoen, would you explain your amendment?
Mr. Chair and committee members, Senator Ingebrigtsen, Senator Housley, I fully expect that your bill is going to pass today, and I visited with Senator Ingebrigtsen briefly. As as a police officer, a working police officer in the metro area, one of the things that I'm concerned with making this automatically a gross misdemeanor is the idea and the lack of, or the push towards the lack of discretion I may have. And if I'm the watch commander, if I'm the senior officer, supervisor, whoever that may be for the state patrol or for the law enforcement agency that's out there, and there's 500 people that show up and I work with, and I'll just use, for example, one of the testifiers, if I decide to work with, if John Thompson is the leader of the group and is the one I communicate with, I'd like to feel like I can build a rapport with Mr. Thompson and say, you know what, if you're going to do this and you're going to work with us to do this safely, it doesn't mean I personally appreciate it, or it doesn't mean I always agree with the protest. I'm not saying that. But I would like the opportunity to feel like there's a trust that can be built, and it's not automatically going to be something that's going to result in an arrest or that the public expects it. They kind of do now. I can go out and arrest any protester on the highway because it's unlawful. I can make them post or be booked into jail, preventing their time, preventing them from coming back, but it's still a misdemeanor. So I'd like to be able to feel like all of a sudden 500 people aren't going to lay down and when we could deal with something in 2 hours versus 12 hours. So that's a difficulty. I don't want the impression for me as a police officer that we're hoping to be able to just arrest people instead of being a part of the discussion. And this is our job, to maintain law and order, and sometimes that comes with negotiation, and it's not always easy. So here's my goal. What I'm hopeful for, and I wish you would just think about this for a minute. My amendment says that if I encounter the protesters or anybody that's partaking in blocking of the freeway or the airport, and I give them a documented warning. So there's an ICR number, we call it a CAD number, that says Bill Ingebrigtsen was warned at this location at this time. We won't even give you a citation, or you might have gotten a citation for the misdemeanor. If you return within 4 hours, then it could be brought up to a gross misdemeanor. I think that does two things. I think that helps our costs, and I'll say why on the cost, because if we automatically charge every one of these as a gross misdemeanor and we actually start charging more, I mean, this is not hand somebody a citation and then that's either payable or they can deal with it in court, but this is booked into jail and stay there, and then it's a formal complaint, which then goes to the county attorney's office. So your bill does have some significant costs to it. I don't see the fiscal note that might be associated with what this will do to the budgets of the county attorneys or local agencies. It's something to consider. That is my goal. And then the bottom, I think in 110 to 114, it brings back in that there's a difference between a misdemeanor fine and penalty and the gross misdemeanor fine, because it took out the misdemeanor fine in the A6 amendment or in the author's amendment, so mine puts that back in. But basically 1.3 to 1.5 gives a 4-hour window where the initial interaction would be a warning or a misdemeanor. And then if within 4 hours, they have the opportunity to stay away for 4 hours. And I think about this, I mean, there's an opportunity here. If you could say it's a pro-Second Amendment rally that spills out. It could be a pro-life rally that rolls out. I mean, it could be a church group that gets big enough because 50 years from now, when we're not here and we're all gone, and the choices that we make are significant. There could be some issue that comes up due to changing populations that our church groups decide they've had enough or feel, Christian or otherwise, that they're upset with something. And so I just think long-term, it's something to consider. I would really like this group's support. I'd be happy to answer questions about it. I will say there is nothing more painful as a police officer to see your partners out on the highway and getting landscaping blocks dropped on their heads. That makes me furious. But now we know, let's clear no more standing on the pedestrian bridges, or if people are gonna be out there, we're gonna clear the bridges. I mean, there are things that we can do to help mitigate that. And yeah, I don't want people to come back. We have to deal with the issues of safety and those concerns. But I will tell you, as a police officer, seeing what is happening, I really want to be seen as a police officer and my fellow police officers as folks who want to engage in the conversation to help prevent exactly what you say, or what was brought up, that we don't want to have these issues that need to protest. I will promise you, unfortunately, we are going to have interactions where police officers are going to have to shoot other people. They are going to have to use force. And I'm all about being open and accountable to that. And I want the public to gain that trust again, that when Dan Schoen may have to be involved with this, they're going to say, okay, we got to give him a check. We got to give him a chance to have that investigation, and we'll protest when the information comes out. But we're still upset. Well, we got to engage back in that conversation right now. It is difficult, and it's difficult for me to watch my profession be targeted that way too, because I think that there are bad actors in every profession, including mine, but most of them are good, almost all, 99%. Other people may have a disagreement with that, and that's their right. But I would like to create a space here where we look like we're trying to help public safety in that manner, but also making sure that we're not automatically saddling people who feel with great emotion that this is the only avenue they have to make a statement. And if we can deal with that, and if we can deal with both ends of that, help create a better avenue for public safety, even if we have to get to the point where we're clearing off the highway, but we're not going to put people in jail overnight or for the weekend, and we can give them the space to go, I had my moment, I will pay my fine. I think this is a good opportunity. And to the crowd, I bring this in because this bill is going to pass. And I'm trying to find the happy medium that maybe both sides can come together and say, I know we're not going to agree on everything in here, but maybe there's some avenue and some middle of the road that brings us together to say, all right, that's good. Because, I look at the Women's March, you bring that up. My 11-year-old daughter and my 7-year-old son were there. There were 20,000 people that got that permit, but there was 100,000 people there. So in theory, this could evolve to the day when we say, well, we have to bring a gross misdemeanor to city streets or all streets. So then my 11-year-old and 7-year-old son and I would then be guilty of a gross misdemeanor, and I don't think I'm that bad of a guy. So I'd really ask you to honestly consider this as a friendly amendment that accomplishes what you're trying to get to, because I think it's going to pass, and I don't think it's completely wrong to be that concerned. And I think it's good that we're having this conversation. It's probably past due time. So, members, that's the question I'd ask, and I'd ask for your support. If Senator Ingebrigtsen says this would be a friendly amendment to bring forth, I won't ask for a roll call, but if it's not, I'm going to ask for a roll call and that be recorded in the journal.
If it's recorded in the journal, Senator Schoen, you need 3 hands for that. Might as well ask for that now. When the time comes, if it does come. All right. Senator Latz, did you have a comment?
Actually, I have a question for Senator Schoen, just to clarify the scope of the amendment. If I'm reading it right, Senator Schoen, the first lines 1.3 to 1.5 apply that 4-hour warning concept to the public nuisance portion of the bill, which applies to freeways. And then lines 1.10 to 14 basically applies that 4-hour warning concept to the airports, the non-force or violence protest at transit or airport properties. Is that right?
Senator Schoen.
Mr. Chair and Senator Latz, I'm going to defer to staff because it's our goal to make sure that that's all encompassing.
Mr. Backus?
Mr. Chair and members, yes, the top half of the amendment applies to the public nuisance crime, which is, again, protesting, obstructing freeway traffic or airport traffic. The lines 1.10 to 1.14 apply specifically to the transit crime. So you were 90% right there, but it's slightly different. But it would it would apply the 4-hour requirement, the warning or citation requirement to both provisions of the bill.
Is that okay, Senator Latz? Okay. Senator Ingebrigtsen, what is your opinion of the?
Thank you, Mr. Chair, and Senator Schoen. I suppose one could say we don't want to really dive into a lot of this stuff, but this is very important business. And let me start off by saying I certainly wouldn't think you and your kids would be bad people if they were out trying to make a point about whatever they're going to make a point about. However, I would be very concerned if one of your children were not there and had to be rushed to the emergency room and they came up against this type of a situation on I-94 or 394, whichever. I think then you might think differently about this. I think you might. Now, there's been testimony said that escalation of crime doesn't pay, doesn't work. Well, then I guess why do we have felonies? Why do we have an escalation? We've moved from drunk driving from misdemeanors to gross misdemeanors to even felony levels because of the danger involved. And the potential danger here involved is as well. You talk about building rapport with a crowd. I don't have a whole lot of experience in the last years. Some of those that may or may not know, I was a sheriff for 16 years, 34 years total. I do remember years ago dealing with power line incidents down in west central Minnesota, where people were protesting the businesses coming through with their towers for this or that. I do know that those became very personal, very, very argumentative. Law enforcement was kind of caught in the middle there, having to enforce the law, similar to what's going on here now. You don't see any officers here testifying on behalf of this because, frankly, they get their marching orders from the legislature. They always have. And I think that's the way it should be. Now, we can disagree as to how that's applied to the public. There's obviously some that disagree. There's no question about that. This idea of cop killings, I don't take that very lightly. I really don't. My partner was killed while on duty, so I've kind of been there, I've also seen an officer who actually had an opportunity to take somebody's life after a knife has been jabbed into his chest, and he had an opportunity to actually end that person's life, and he chose not to do that because it was a young person. Those are really tough deals, as you well know. So this idea that, and that's not what the bill is about, Mr. Chairman and members, it's not about police taking of lives here. There are laws in place for that, and I hope that they're being dealt with. If they're not, then this group needs to come to you and I and put a bill together for extra protection or whatever they think they've been wronged, okay? So negotiating with people that are very angry at the scene doesn't work very well. Already, when you get to that scene, and we're talking about I-94, where people were actually throwing bricks and where some officers actually got hurt. I think there was 21 total. They were told to leave the scene. They were given that warning. They were given the warning similar to what you're talking about. They made a choice to stay there. But the offense was a misdemeanor. They get a ticket written and they go right back out on the line again. A gross misdemeanor escalates to something higher than that. You and I know that. That goes to a booking process where they'll actually probably have to spend the night in jail and go through the process. So you're at least eliminating them coming back. Or they could, under your amendment, they would sit and wait 4 hours and say, okay, my time's up, now I can go back. Well, really? That's not what we're about. You've been given the warning when you have a megaphone by a commander on the scene to say you have to clear the freeway. You just have to. And if you don't, then you're subject to arrest. And the booking and release I did talk about. So I do not call this a friendly, I will not take this as a friendly amendment. I ask that the committee vote against it, and I will ask also for a roll call in this vote.
There has been a roll call already requested. Senator Schoen.
Mr. Chair and Senator Ingebrigtsen, and I respect your position and your service. The only thing I will say is that it is absolutely okay for me to take custody of an individual on the highway today. And it is okay as a misdemeanor for them to be booked into jail and have to go through that process and be held while that process takes place and post bail or bond. That's okay today. And I agree that there's a time when there are circumstances that when I am working, that it is a better opportunity when the level of the crime is increased because it provides some opportunity to mitigate a bigger situation. And that is all I'm trying to do here with this window of 4 hours. I'd be open to a different number, Senator Ingebrigtsen, if you said it was 5 or 6 or 10. I mean, I'd be open to that. I'm really trying to say that I don't think that the gross misdemeanor part of this on the initial response is the piece that actually solves what you're trying to solve. I think that there is opportunity to prevent, the opportunity to clear up a situation if it is such a jeopardy to public safety within it being a misdemeanor and the potential for being a gross misdemeanor. I just think that we have so many people that it would, I don't need to get into it too far. I mean, you've heard my plea to you just to say, you know, let me do my job. I think that once it's an automatic gross misdemeanor, you're putting our troopers and you're putting our officers into a position from policymakers that says, why in the hell aren't you doing something about this? When in reality, they are trying to do something about it instead of taking 12 hours or forcing a forceful encounter. We're doing everything we can out there some days to not have to use force. I told this story to Senator Pappas before, and 15 years I've been a police officer, and I've taught use of force, hand-to-hand combat for a department. I've never lost a fight, but every single one of them hurt. I don't want to do it anymore, and I don't want to see anybody else get hurt, and I do a better job talking to people than I did 15 years ago. I'm sure you found the same thing from when you were first in law enforcement, Senator Ingebrigtsen, that sometimes words work better. And if I can get somebody to start leading down the path, I may look like I lost, but sometimes you win by losing. And let's just get off the freeway. If it's the next exit, we can deal with that. Believe me, I've said the same thing you have said. I'm upset at the idea if I can't get to a partner, if I can't get my kid to the hospital, I'd be furious out there too. I get it. I really do. It's weighing that out of if people lay down and we are going to book and hold 500 people into a county jail over a gross misdemeanor, how much is that going to cost? How long is that going to take? Because that's not 2 hours, that's dozen or plus hours trying to remove all those folks and to do it safely. And if everybody lays down, how many back injuries? We're just hoisting people off the freeway. If I can create a situation where they'll walk off and work with us in a quicker ratio, I think that builds good community between law enforcement and the communities as well. And I'll plead to the members of this committee, I want you to think about that, that this isn't a perfect scenario. I don't know that I'm making anybody's friend here on this situation, having to, be a little this way and a little that way. But it just seems like this wouldn't be the worst thing as a gesture on this particular piece of legislation to say, you know what, you're right. If we can create this space, and if you come back, then you knew for darn sure you're definitely going to spend the weekend in jail. I agree with that. We can work with. I'll vote for it then.
Senator Latz.
Mr. Chairman, I would encourage members on the committee to consider voting for this amendment. I think primarily because what Senator Schoen as I understand it, trying to accomplish here is finding a way to be able to clear the highway more quickly than by having the first initial penalty be a straight gross misdemeanor. And if the ultimate purpose here, I mean, I think it's fair to assume that there are going to be those, even if it deters half the people from going onto the highway, there'll be those who will not be deterred by the gross misdemeanor penalty, and they will still cause great disruption on the freeway. So then the question is, how do we open up that freeway to traffic the most quickly and with the least confrontation between law enforcement and protesters as possible? And if this amendment goes on, it creates, I think, a pathway to clear the highway more quickly and with the least conflict. I think it's really an analysis of what's going to be the best tactic in these cases to accomplish the ultimate goal for purposes of keeping the freeway open. So if one assumes that, and I know this is not an assumption everyone in this room is making, but if certainly the goal of the legislation is to attempt to keep the freeways clear, or the airport access clear, seems to me you're more likely to accomplish that goal with this amendment on it than without it. So I'd encourage members to vote for the amendment for that reason.
Senator Ingebrigtsen, I had a question for you. Do you think it's appropriate for the legislature to create limitations or routes of tactics for law enforcement as they're trying to deal with a potentially dangerous situation on a freeway that's being obstructed?
Mr. Chair, thank you for the question. I think it's something that they have to deal with. Certainly, if something like this occurs, and let's not fool anybody. We're talking about the incidents that have happened around here as of recent, when they have to reroute things. Nobody coming west into the Minneapolis-St. Paul area knows that this is ahead, and they might be in a hurry to get to the bedside of their loved one someplace on the east side of the city, or vice versa. And they may not like driving in the city, like some of us folks out there in rural Minnesota don't like much to do. And they come up against this, it becomes very confusing. But yes, to your answer is that they would have to create a different route, that'd be putting semi-trucks, so that would be putting everything in some areas, into neighborhoods, simply because somebody basically is out trying to, exercise their constitutional right under the First Amendment, and it had escalated to the point where that movement of traffic has stopped. So I'm sure there has been many different.
The question I had for you, Senator, was should the legislature create either limitations or specific routes of tactics for law enforcement through legislation like this?
No, I don't think so.
All right.
No,
Senator
really
Ralph?
don't. I think
one other question, Senator. Does a police officer have to mandatorily enforce the law, or do they have a certain discretion in order to exercise in a setting like this?
Mr. Chair, that's a good question. No, they don't. And as Senator Schoen knows, if you've got somebody close to home that might have had a few too many to drink, he and I know exactly what I'm talking about. We're going to let it go this time, and it's my discretion. I'm going to let you go. I'm going to take your keys for the night, or I'm going to give your keys to your wife. You're not going to drive anymore. But if I catch you out here again, it's going to be a different story. And that's done all the time. It truly is. Okay. But when you are telling people to disperse, that are blocking commerce, that are blocking potentially law enforcement, potentially fire trucks from going through to respond to the public's safety, you have gone over the top. You simply have. I wouldn't be here if I wouldn't feel strongly about that. Sorry.
Senator Latz, then Senator Ralph, and then back to Senator Schoen.
Thank you, Mr. Chairman. What Senator Ingebrigtsen just said are arguments in favor of passing the bill as the bill. And they can be applied to the bill whether it's amended with the A8 or not amended with the A8. But the question before the committee at this moment is whether or not to adopt the A8 amendment. And I would suggest that this legislature all the time passes laws that have a direct impact on the tactics that police have available to them in one situation or another, the tools that they have at their disposal in one situation or another, whether to utilize this particular law or choose to enforce it, whether to enforce that particular law at the time. So if we were to pass this amendment, I don't think it would be anything new that this legislature has done. It would simply become a part of the legal fabric that law enforcement works under, and it would be another tool that they could utilize if they felt it would be beneficial at the scene at the time.
Lord knows they need more tools. Lord knows they need more tools.
Mr. Thompson, please, Mr. Thompson.
And the purpose of this amendment would be to give the law enforcement the tools to try to deal with this in a more peaceful manner as at their discretion. And it says nothing at all about the validity of the protest or anything like that. The amendment before us is simply about whether or not there is the additional tool available to the police to try to deal with a lawful protest, or an unlawful protest, rather. It might well be a valid and purposeful protest, but one that is technically unlawful under the law, in a manner that will be more peaceful in that regard. So I think it would give the additional tool, and the committee should support providing that additional tool to law enforcement. If for some reason they choose not to exercise that, you know, and they issue a citation and the person comes back, they still have the discretion whether or not to conduct the arrest at that point or to use other tools and their discretion not to arrest someone at that point.
Senator Ralph on the amendment.
Thank you, Mr. Chair. Senator Schoen, I guess first of all, I am very concerned about chilling of First Amendment rights. I want everyone to understand that. And there is a great need when we craft legislation to strike a balance between all of the rights that we have. The First Amendment right of free speech is not unlimited. And in fact, even within that right, there are layers. Absolutely pure speech, as we are engaging in today, is given a much higher protection than symbolic or demonstrated speech, and that there is clear case law all the way to the Supreme Court interpreting the Constitution that makes that separation. And we must be very careful as we go forward to ensure that while we protect the right of speech and understand that there are sometimes cases where just holding up a sign may not be enough. On the other hand, my question is this. First of all, as I understand it, there are several discretionary points in the law enforcement process. The first responder goes to the scene. They observe a crime being committed. The blocking of the freeway today is a crime. And I would point out that as drafted, the amendment with the amendment that the First Amendment was placed on this bill, we are making very little, if any, expansion on the scope of the criminal activity. We are trying very carefully to restrict the impact on that right of free speech versus our right under Article 4, Section 2 of the Constitution to freely travel. And that is also a constitutional right. More importantly, the right of people to be protected, the people who are in danger, someone who's having a heart attack, and an ambulance needs to get through, and that's the only fast way through, otherwise it's a long, torturous trip through the city streets, needs to be protected. And I guess my question to you on this amendment is how that furthers that process of quickly clearing and taking care of the problem. And number two, because of prosecutorial discretion and because of law officer discretion, why not, we're talking about tools, why not give that law officer the right to say to this person, look, this is serious business, my friend. You have endangered people. Now, I will give you the opportunity if you will clear this place peacefully. Nothing else will happen. If I have to arrest you, you face significant and serious consequences. That's a tool that I do believe that peace officers can and do use. And I guess my question is, how does adding a 4-hour window within which we would change the level of severity of the crime implement trying to clear that freeway? The object here is to clear the freeway. I don't think anybody disagrees. The protest has been made. The people have spoken. And now it's time to take that protest and move it to a safe place, allow it to continue peacefully, and I will defend that right to the death, that people be allowed to do that. But when we conflict that right with the right of free travel and the right of safety in our persons and the right to enjoy the pursuit of liberty and freedom, that is where I have to draw the line. And I ask how your amendment furthers that protection, furthers that process.
Senator Schoen?
Mr. Chair, Senator Ralph, you're getting good at this being a senator thing. That was a real good statement with a bit of a question, and I'd do it myself. So I want to make sure, Senator Ralph, Mr. Chair, Senator Ralph, a question. I mean, you understand that it's Senator Ingebrigtsen's bill that created the gross misdemeanor from a misdemeanor, correct?
Senator Ralph?
Okay, Mr. Chair.
Yes, Senator Schoen, I full well understand that.
Senator Ralph, what my amendment is trying to do is say, let's just not create that immediately. It is, you asked me, how does this help deal with that? I can go arrest you out on that freeway right now. I can walk up to you and arrest you and remove you from that highway with a misdemeanor. And I can bring you in and book you into jail for that crime today, if you do that. It is not uncommon for policymakers, whether it's us or mayors or administrators, to view an escalation, meaning that if you create an automatic and you say it's a misdemeanor today, but now we're going to say it's automatically a gross misdemeanor. That is, and here's why I get concerned with that right away, because it automatically turns into some departments in some areas and communities will say, why did they have discretion on this? This is a gross misdemeanor. They're supposed to go to jail and spend the night in jail. And that isn't always the case. So now it's up to a year penalty versus 90 days and the fine. And those are the significant changes that I think, and this, from the law enforcement standpoint, we're going to go do the job. Now, as a policymaker standpoint, I get concerned about the message, even sometimes with the bills that we draft, that we send to people, like you said, the right to free speech. You're right. There's nothing that says you have the right to block the highway, but the message you're sending is a message of what is in the First Amendment, right? Location isn't always protected, but that is part of the reason why those protests happen. So I see it as a quicker maneuver, because if Senator Limmer is leading the protest and I build a rapport with him and we work this out to be dealt with in 2 hours, and I say, Senator Limmer, everybody here has gotten a warning, and we've got names and we've done this, I have that discretion, and I feel more comfortable as the supervisor on scene or the officer that has to deal with it on scene with that discretion, that I'm not going to go back into work tomorrow morning and we'll say, why did you do this, or why did you not arrest everybody? So what I'm telling you is that it doesn't happen across the board. You're not building in that automatically there is no discretion, but it leads that direction. This 4-hour window leaves the statement that this still is a misdemeanor crime and can be dealt with as it has been, as it should be. If you need to remove people, go remove them. If they come back and continue the disruption, then go spend the weekend in jail. I'm open to discussion about the time, because I am sincerely genuine about my feeling on both sides of this. And if you don't think 4 hours is the number, I'm open to discussion, because I think it's the right thing to do. This is going to pass. I just don't think it should pass as an automatic gross misdemeanor right from the start.
Senator Ralph, and then we'll vote.
Thank you, Mr. Chair. To the point, I still am uncertain from what you're telling me, and I do have some experience with prosecution, having been a prosecutor at one time myself and dealt with police officers in that capacity. I'm still uncertain as to how your amendment alters the situation on the ground. The fact that there's a gross misdemeanor, let me finish and all. The fact that there's a gross misdemeanor penalty available does not mean it has to be exercised. And my concern is the speed with which we deal with the situation. And I respect and in fact encourage the use of even a little bit of outside the box thinking on the part of police officers. They need that protection to be able to do that. And so I'm still uncertain as to, and I agree, maybe there's some way we need to tweak this, but I'm uncertain as to how this helps it. I just don't see it because the discretion already exists to say, get out of here. If I see you again in another hour, you're going to jail. I mean, I think the police officer can do that, and they can do it with a lot of force, especially where there's now suddenly this 4-hour restriction that says, well, okay, I got to keep track of this guy for 4 hours, as opposed to saying, look, get out of here. If I see you again, you're going to jail. And to try and guesstimate how long that person should be gone from the scene seems to me, first of all, to defeat the purpose, because it tells them, gee, I wait 4 hours and I can come back and I don't get penalized. Whereas if they are faced with the immediate threat of an enhanced penalty, and that's what this is an enhanced penalty, and we can get into why we do that, but and there's some discussion about the penalty fitting the crime, but for the purpose of your amendment, I still don't understand how it changes or in fact improves the situation as opposed to the police officer's absolute ability to look that person in the eye and say, I respect you, please get out of here, we have a situation we need to clear, you can leave, but if I see you back here again, you're going to the slammer. And I don't see how your amendment aids or changes that or creates a better situation. Thank you.
Mr. Chair.
I think that probably was rhetorical on
Well, I mean, how
part.
he's arguing on behalf of my amendment, Mr. Chair.
Well,
and that's
Senator
my
Senator
opinion.
Schoen,
So, I mean, it accomplishes what you're saying. And it makes it easier.
Senator Pappas?
Mr. Chairman, we're spending a lot of time on this amendment, and there still is the basic bill to be discussed. So I'm just getting worried about how much longer we're going to go, because I do have a lot of questions for Senator Ingebrigtsen. I never really got to ask him any questions about the bill.
My sentiments exactly, Senator Pappas. We have Senator Schoen's amendment before us, the A8 amendment. There was a roll call that has been asked and a Rule 1210 request that the roll call be published in the Senate Journal. And I did see 3 hands to that effect. All those in, would the Secretary take the roll?
Senator Limmer?
No.
Senator Anderson?
No.
Senator Hall?
No.
Senator Ingebrigtsen?
No.
Senator Johnson?
No.
Senator Latz?
Yes.
Senator Pappas?
Yes.
Senator Ralph?
No.
Senator Schoen?
Yes.
There being 3 votes yes, no, that is, yes. There being 3 votes, 3 yes votes, and 6 no votes, the motion is not adopted. Senator Pappas, you had questions regarding the bill.
Thank you, Mr. Chairman. And Senator Ingebrigtsen, could you just be clear with me on this current language in your amendment? This does not impact trunk highways. For example, Highway 61, University Avenue, West 7th Street, Robert Street. Are any of those streets impacted by this legislation?
Senator Ingebrigtsen.
Mr. Chair, I would refer to the legal counsel, but I believe you're right. Is that correct?
Mr. Backus?
Mr. Chair and members, yes, Senator Pappas, if you look at the definition of freeway on line 1.21 to 1.22, those are the roads it applies to. So it'd have to be divided, and the egress and access would have to be through an exit and an entrance ramp.
Thank you, Mr. Backus. It's actually kind of
Pappas.
hard to hear you if you've been turning on your mic.
You'll have to speak up, Mr. Backus.
I did hear you, though, but I don't know if
Mr.
anyone
Chair,
else
I
did.
turned it on. It doesn't seem to be, I don't know if it's not working properly. I'll try to speak louder next time.
I'll have to use your outdoor voice.
Then, Mr. Chairman?
Senator Pappas.
Thank you for that answer. Senator Ingebrigtsen, could you just kind of explain to us what the rationale is for having additional penalties? Since, I mean, my research has shown me that there's a lot of books already, a lot of our laws already on the books. Like, for example, there's laws about trespassing, disorderly conduct, failure to obey lawful order, unlawful assembly, obstruction of the legal process with force, public nuisance, gross misdemeanor riot. I mean, don't we already have plenty of laws to deal with any situation that could arise?
Senator Ingebrigtsen.
Thank you, Mr. Chair. And Senator Pappas, you're right. There are laws that pertain to escalation of crimes, if you will. And let's go to the I-94 protests, if you will. There are laws that are felonious in nature when an officer gets hurt. If you can prove as to who that might have been that threw that rock or threw that piece of concrete or whatever, Molotov cocktail, that escalates up to a felony. But that should escalate up to a felony. Other crimes, you have sexual predators in the different degrees, depending upon the crime. Absolutely, there are those on the book. But those sanctions, it seems to me, are laws that are passed here in the legislature because of the seriousness and maybe the less seriousness of a crime. You may talk to somebody who is the parent of a child who's been sexually touched versus actually some penetration. They wouldn't agree that. They would agree that it should go all the way. But we in the legislature do, I think, prudently issue the penalties for the crime, and that's the way it should be. I don't agree with you at all. Or excuse me, I don't disagree with you at all. Is it mostly because we don't agree I said that? No, I'm sorry. That was a miscue on my part.
Senator Pappas.
Thank you, Mr. Chairman. So, Senator Ingebrigtsen, you're then saying that the current laws that we have on the books somehow aren't adequate to address the situation? That, I mean, I'm trying to understand how this is going to help when there's already all these charges that could be levied against protesters. Then how does creating this new law, other than kind of make us all, some people feel good that they're doing something, when, you know, as Senator Schoen said, he can arrest people now and take them to jail if it's necessary.
Senator Ingebrigtsen.
Thank you, Mr. Chair. And Senator, you're right. However, let's use the analogy of a slap on the hand versus an actual law that really actually is going to mean something that is more sanction, like a gross misdemeanor over a misdemeanor. I mean, it just is. In law, I think a misdemeanor is a fine up to a certain degree. A gross misdemeanor is the next step up. I don't think it's unreasonable at all, and we've had a long discussion here, and I think a good one, about discretionary. And again, this turns out to be about police, and unfortunately that, you know, we should be looking beyond that. They have the discretion to get on the microphone and say, disperse or you will be subject to arrest. But I guess we've already dealt with the amendment, but by having a warning like that, is it really going to stop anything? Are we going to have maybe 18 officers hurt instead of 21? This is serious stuff, and they should disperse when they're blocking a freeway. Simple as that. And there's a lot of Minnesotans that agree with that. They said that should not be going on.
Senator Pappas.
Yeah, Mr. Chairman, I'm just trying to understand that a gross misdemeanor is a serious charge. I mean, as I think her name was Nelson from the ACLU, she mentioned this, that gross misdemeanors are domestic violence, where someone is being physically assaulted, malicious punishment of child, which is my bill, by the way. These are very serious charges, and we're kind of equating that with kind of temporarily inconveniencing people on a freeway. And I just want to talk about that a little bit, because you talked, Senator Ralph, you mentioned ambulances or fire engines. I'm sure that ambulances and fire engines are going to be allowed through any kind of a demonstration. I mean, we have freeway disruptions all the time. First of all, we have rush hour. we have accidents, we have things like the state fair or sports games, we have construction. I mean, all these things, ambulances have to figure out a way around, and I'm sure they have alternative paths. I'm sure they can still get on the freeway. I can't believe that any demonstrator is going to lay down in front of an ambulance when they're trying to get to a hospital. So I think this whole idea of safety, I think, is overrated. I think there are some safety issues for people being on the freeway and cars still being allowed through, and that's certainly what the police are doing, is they're preventing cars from coming through because of the danger to the protesters of being on a freeway. So I don't really buy that argument very much, and I am concerned about this enhancement, that we're equating this with some pretty serious crimes. You mentioned, child abuse and other serious crimes. So, given the fact that law enforcement already has tools, if they need to use discretion or arrest people, here's another question I have. How does this really help law enforcement, say, de-escalate a situation? We don't really want a riot, and we don't want a violent protest. And if the police feel, as Senator Schoen said, that, yeah, I got to take this as serious now, the legislature said this is a gross misdemeanor, how is that going to help de-escalate the situation between the police and the protesters?
Senator Ingebrigtsen.
Mr. Chair and Senator Pappas, there's choices in life. I guess I don't know how else to answer it. If I'm told, and have been protesting on the freeway for the past 2 hours, and now we've got 3 and 4 times as much law enforcement, we may have some ambulances there in case somebody gets hurt. They prepare very well for things like this. Unfortunately, there's an awful lot of resources being utilized, and they do, and they're very, very patient, what I've been able to see. But there comes a time when you have to make a choice as a person who is going to stand out in front of a car. Is that going to, and if you find out that that's no longer going to be a misdemeanor, it's going to be a gross misdemeanor, and it's going to go on your record, then it's my choice whether I decide I want to stick around and get that gross misdemeanor charge. That would be my choice. And I think law enforcement, has shown that kind of discretion, shown that kind of patience and discretion. But I think it comes a time when a lot of resources, and again, we're not talking about recovering any of them here in this particular bill, but a lot of our resources that could be spent on other good areas, and we all know about dollars and cents around here where they could be spent. We could spend our money a lot wiser than constantly letting that go. There has to be something in place to eliminate the public safety issue that's at hand. And this is my feeling as to how to do it.
Senator Pappas.
Just one final comment. And I think Mr. Thompson brought up a good point when we talked about maybe we should spend this amount of energy on what the underlying causes are for protests. That civil disobedience is a time-honored strategy in our country. It's been used since the founding of the country. And I think this bill is just going to have a chilling effect on people's feeling that they have First Amendment rights to protest. Yes, there may be some inconvenience around, but inconvenience involved, but that's nothing compared to the kind of issues, the kind of inequalities we have in our society.
Senator Ralph.
Thank you, Mr. Chairman. Senator Pappas, since you called my name out, I wish to respond a little bit. This is not about inconvenience. This is about safety. Now, that being said, I do have a concern that, having listened to this, that the elevation to the gross misdemeanor alone in the absence of some other tools is going to accomplish the purpose. And this troubles me. We have a situation where people are making a statement. Sometimes emotions run high, and the question becomes, is the deterrence going to defuse that situation, give us tools to clear that freeway quickly? That is my concern. And Senator Schoen, you were somewhat correct in indicating that I was kind of speaking to your amendment. I was speaking to it more in a principle idea of, is there more we can do with this to provide a clear path that will tell people you're exercising your First Amendment rights and we support that, but there comes a time when that First Amendment right butts up against public safety and the right of people to use the freeways. And I have to ask myself, is this going to accomplish it? So I do have some concerns, but I am very concerned about the fact of the safety, and I just wanted to make that clear, that I'm not talking about inconvenience here. That's fine. If I have to sit in my car for 2 hours, that's fine. But if my mother is dying and I'm trying to get to her, that's not inconvenience. If someone has had a heart attack and the ambulance is delayed 15 or 20 minutes, or worse, a stroke, where that time factor could mean the difference between a normal life and spending the life in a chair, to me, that is something we need to be extremely concerned about. And I concern myself that it is the issue not of inconvenience, but of public safety. And my only question is, does this bill accomplish that? And that's the only question I have. Thank you, Mr. Chair.
Senator Ingebrigtsen, do you have a motion?
Mr. Chair, I'd like to move the bill, if I could, at this point, unless there's more discussion.
Senator Latz.
Thank you, Mr. Chairman. I was kind of hoping Senator Ralph would draw a conclusion, answer his own question, because I'm curious as to his conclusion on that, because I'm struggling with the same issues. I'm a strong believer in First Amendment rights and the right to protest and the change that's appropriate that can come from that, and the need to make underlying changes in society. And in fact, last budget cycle, the legislature put $34 million into equity-related initiatives to try to start addressing or continue addressing more robustly some of those underlying issues of disparities. And we've got proposals, and we put money into better crisis de-escalation training for law enforcement, and we've got proposals to do even more of that this year and some requirements for that this year. And we've carried, in the last 4 years, we've passed a lot of legislation that has taken steps toward, I think, reforming the criminal justice system in ways that are more fair to people. But I'm also very concerned about the public safety aspects of this. And what we have before us now, I think, even more so than originally introduced, is a very narrow bill targeting freeways. If you're stuck on a car already on the freeway and you can't get off of the freeway, that's a problem too. Whether you're trying to get to the bed of someone who's dying, or if you're a physician who's trying to get to care for someone, or whatever the circumstances may be. And not only do you get diverted around it if you're not on the freeway yet, but if you're on the freeway and all of the access and egress points are blocked off, you can't get off of the freeway either. And I know there are some in the audience that are shaking their heads no at this and the comments that Senator Ralph made, but those are the kinds of things that public policy makers who are passing laws have to factor in, no matter how much we agree with the purpose and the motives and the goals of the protesters in a particular situation. The bill that we have now does not say anything about when to protest or how to protest or why to protest. It simply very narrowly increases the penalty for where that protest occurs. And in areas where I think the public safety is of a great concern. And I would hesitate to add, this is not at all about race. There are a variety of reasons why there have been protests, and I know some of the most recent motivations, and I agree with them, are worthy of protest and vociferous protest at that, the killing of Philandro Castile among them. But I would not agree that that this bill is motivated or is about racial protests relating to racial issues. It's about protests in general, in particular their location. And again, from the original bill, which was much broader than this is a much more narrowly proscribed than that. It is, and we do have other laws on the books that deal with conduct of persons, but for example, the riot charges that were brought against a number of people in the I-94 protests before, they were dismissed because to prove riot, you have to prove that there was an act or threat of violence. And that that was not, the prosecutor didn't have the ability to prove that in those particular cases, so that's why they were dismissed. But this bill is about the presence on the freeway, not more than that. This was a tough one for me because I feel so strongly about the First Amendment rights to be able to protest. But I think on balance, I think there is a lot of room left for protests all over the state, except very narrowly proscribing them a little bit further on freeways and on airport access locations. And for that reason, I think this bill is carefully measured. I'm going to support it.
Thank you, Senator Latz. Senator Hall, ending comment?
Very much so. I'd just like a roll call vote if we could, and this would be also put into the Senate Journal.
Senator Han has asked for a roll call vote, and that the Senator Hall, what did I, Senator Han, he's not even here anymore. Better be careful what I say. Senator Hall has asked for a roll call and to impose Rule 1210. I need to see 3 hands to put that vote in the Senate Journal. Seeing 3, it will be done. Senator Ingebrigtsen renews his motion that Senate file, what is it? 676 as amended, be recommended to pass and move to the Senate floor.
That's correct, Mr.
The
Chair.
Secretary will call the roll call.
Senator Limmer,
Yes.
Senator Anderson,
Yes.
Senator Hall,
Yes.
Senator Ingebrigtsen,
Yes.
Senator Johnson,
Yes.
Senator Latz, Senator Pappas,
No.
Senator Schoen,
No.
Senator Ralph,
Yes.
There being 7 yes votes and 2 no votes, the motion prevails. There's no further business before the committee. The meeting is adjourned.